Good afternoon, and welcome to today's webinar, Litigation Finance Market Process. This is episode 2 of Financial Poise's two-part series on commercial litigation funding. Episode 1 is titled Introduction to Commercial Litigation Finance. It premiered live on April 25th and is available for replay. You can read more about Financial Poise on slides 2 and 49 and Daily DAC on slide 45. Before we begin, I'd like to thank our sponsors. We have Mood. Mood is an online cannabis dispensary. Type to Learn is a digital learning solutions provider, and Max Asset is an online provider of asset sale and auction solutions. You can read about them on slides 3 and 4 and 47 and 48. So today's topic is the litigation finance process, the market process. And just to sort of tee up the situation, litigation costs have become significantly higher. Cases are taking longer to resolve. There are greater burdens on litigants. And litigation finance is a growing tool. And to give you some perspective, according to a Westfleet market report, there are approximately 40 active funders. Collectively, they manage $15.3 billion. In 2023, they committed $2.7 billion. The average investment size was $4.8 million for a single case and $9.9 million for a portfolio of cases. And the breakdown is about 34% single matters versus 66 portfolio funding. So to discuss the litigation finance market process, we've assembled a great crew. Distinguished faculty, we have Jeffrey Lula, who is a principal at GLS Capital, which is a litigation finance provider. Matt Blumenstein is the director and head of underwriting at Statera Capital, another litigation finance provider. Jeremy Weitzman is a business and finance attorney and principal at Much Shellist, and he advises clients on litigation finance matters. And Paul Haskell is also a business and finance attorney and partner at Crowell and Mooring, and he likewise advises clients on litigation financing matters, distressed debt, and claims trading. You can read their bios on slides 39 to 44. Okay, we're going to dive in. I guess actually one last thing, just to note a disclaimer, which is available on slide 5. You are not our clients. We are not your lawyers. This is an educational webinar to give you a sort of a general overview of issues to consider. And you should consult your attorneys or any of Jeremy and Paul if you have specific questions about a situation. So I think it'll be helpful to just have a brief recap from episode 1 for those of you who didn't participate in that episode. And Jeff, I'm going to start with you. Can you just give us an overview? Tell us, what is litigation finance or funding?
Well, thank you so much for the introduction. Just to kind of recap on that, litigation funding at its absolute core is kind of treating litigation, usually plaintiff side litigation, as an asset, something that you can finance or lend money into on what's effectively a non-recourse basis, using it as collateral in different forms. Now, this can be a single case financing, this can be a portfolio of cases, this can be with a client, or this can be with a law firm. And so there's lots of different mechanisms by which to do that. But, litigation funding really is sort of that conceptual idea of using litigation as that type of asset and the different structures in which financing, funding, monetization, or other types of de-risking of the litigation can occur, because your average bank is not going to look at your litigation and view it as an asset in the way that a litigation funder really is institutionally designed to be able to do that.
Great. And Matt, maybe you can give us a quick overview. Who are the key players in this marketplace or sort of transactional world?
Thanks, David. Thanks for the introduction. It's a pleasure to be here. the first key player, of course, is the plaintiff, the claimant, the client, what have you. Then there's the funder, the finance firm, the litigation finance firm. Importantly, litigation finance provider is not a lawyer for the plaintiff. It's a contractual counterparty, a financial counterparty, and thus doesn't have a attorney-client relationship, and very importantly, has no control over a case, not even to the extent that, for example, an insurance company may have on the defense side. And then, of course, there's the lawyers. Typically, or I'd say in the vast majority of cases, the funding provided by the litigation finance firm is used in part to pay legal fees. And there's also, I would include in the ecosystem, sort of service providers, including, importantly, experts or other service providers who incur hard costs that need to be paid for in the course of litigation. So I think those are probably the key players in the typical deal structure.
Great, thanks. Paul, turning to you, maybe you can tell us a little bit about who the different types of funders are.
Yes, and thank you. Thanks, David, for the introduction. Thanks for having us here. So I think the way to think about it, there are three main buckets of funders. The first being sort of dedicated classic litigation funding firms, they're a form of investment firm, and their sole providence is to invest in litigation. They generally are made up of litigators or former litigators, and so they're quite expert in evaluating the merit of the case, in advancing it, and in underwriting the case itself. So often they don't use outside counsel because they have that expertise themselves. They tend to have portfolios of other cases, so full portfolio, so they are able to judge what types of cases are successful, what are not, and so they're quite skilled in this. The second category of funders are really the non-dedicated funders, and these tend to be multi-strategy investment funds, either hedge funds or private equity funds, who invest in what we call the alternative investment space. They find litigation funding attractive because it is exactly different from their other investments. It is non-correlated to the market, or completely non-correlated to the market. So for them, it's a really nice part of a multi-strategy portfolio. They're much more likely to use outside counsel because either they'll have no litigators in-house or very few. And arguably, since interest rates have been historically low for a long period of time, so during that period when there were low interest rates, investments of this type were very attractive as well for multi-strategy funds seeking yield. The third category of funders are really opportunistic, so that it's not something that they do in the normal course of their business, but they find an opportunity either because they're involved in a transaction as an investor and they see that there's an opportunity to fund a third party in connection with litigation, and either because there's a financial gain to be had from that, or non-financial gain, like there's a political issue or a strategic or emotional issue.
And Jeremy, given what Matt said about the litigation financing firms tending to be more passive than active and not necessarily exerting control, what would cause a client or a litigant or a party to want to pick one type of funding source versus the other? What are sort of the pros and cons from the client side of going with a dedicated funder versus a hedge fund or an opportunistic funder?
Sure. So the answer to that largely depends, from my perspective, on what is that fundee looking to get out of the relationship, right? In other words, are they looking to just get cash to fund, or are they looking for someone that's going to help strategize with them? be a good set of eyes and ears as to the merits of the case. So, when you're talking about your traditional litigation funder, right, with experienced practicing attorneys, a lot of risk analysis typically in-house, if you present your case to them and they say, I think I'm going to take a pass, that's good information for the plaintiff to have, right? But if at the end of the day somebody feels really strong about their case and they don't necessarily want or need that additional layer of expertise or analysis, and they're just looking for funding, it's going to be who gives them the best deal, right? If you go to, if you're looking to get your car repaired, you can go to the dealer, you can go to an independent shop, or you can go to your buddy down the street. Your buddy down the street is going to be the cheapest, perhaps. Is it going to get it done? Depends on, what it is you need done, right? So it's really, what is that fundee looking for? And if it's just about economics, then any of these are perhaps fine. If you're looking for some more expertise and guidance and know-how, then you're going to probably want to tilt towards looking more towards the dedicated litigation funder.
David, if I may interject briefly, I made a critical omission in response to the question about key players by leaving out Jeremy and Paul and their ilk, which is a increasingly experienced and expert group of lawyers who can advise and assist with funding deals. And they're, a critical component of, I'm tempted to say, every deal in the litigation finance space. So it's a pleasure to be on with them, and they're obviously a critical and indispensable part of the ecosystem that I left out. I'd also tag on to Jeremy's answer that, and they see the field from a different perspective than we do at Statera or any given funder might. But I think that the experience that counterparties have with funders may also be a criterion in deciding especially if the available terms are close or even identical. And at Statera, we pride ourselves on being sort of easy to use and providing a painless process and an efficient and speedy process. I don't think we've ever had a counterparty who wasn't interested in getting the deal closed as soon as possible. So those are a couple other factors that may inform a fundee's choice of finance provider.
So perhaps foreshadowing something we'll talk about in a little bit. As you make those comments, Matt, I'm sort of reminded of my days working with financing companies in my prior life. So getting term sheets from lenders, indicative terms for a loan, and really trying to figure out, are you competing on price? Are you competing on sort of industry expertise, quality of service, and things like that. So we'll talk about that. So one of the things I noticed in preparing for the webinars, I visited Jeff's firm's website and offering them a free plug. They do have a litigation finance 101 guide that you can see on their website. And one of the things that guide talks about is the various sort of stages of litigation. And maybe, Jeff, you could just quickly run through those various stages, and we'll then sort of turn to when's the best time to engage with the litigation finance providers.
I'd be happy to, and I appreciate the free plug for the GLS website. I helped put together that guide because of just all the questions we were receiving about some of the basics of litigation. And it's easy for us, sophisticated players in the field to forget that a lot of the people that are looking at funding are not nearly as experienced as we are. And so in terms of kind of the life cycle of litigation, And I'm really focused on US litigation, although in reality, arbitration and even some areas of foreign litigation tend to become increasingly Americanized. So a lot of litigation looks increasingly like this, but this is really the life cycle of US litigation. So you start off by filing your complaint, your pleading. The plaintiff is putting forth the basic allegations of what they thought was done wrong and what they want to recover out of it. That can be very detailed, that can be very simple, depending upon the case and the forum. The defendant may then have a chance to rebut that or try to dismiss. But in most, sophisticated cases, it then moves on to discovery. Discovery is just sharing of facts. This is when documents get served back and forth. This is when depositions happen, and information gets moved back and forth. After that, we often do expert discovery. This is when sophisticated professionals are brought in for opinions on damages or other areas. And, those are sometimes reports, those are often deposed, and it becomes sort of, as you would imagine, the larger the case is, the more likely experts are brought in to be necessary supplemental parts of the case. From there, we start to kind of move towards trial. There may be summary judgment in advance of it, but as you get close to trial, that's when the lawyers and the costs often will really ramp up. And I think everyone really knows what a trial looks like, but it can be a short endeavor. It can be an extremely long, months-long trial for complicated circumstances. And then at the end, whether done by a judge or a jury, you get a verdict or a judgment on the back end. If you're the plaintiff, hopefully a very big damages award. If you're the defendant, hopefully a finding of no liability. And after all that's done, the party that's not happy with the outcome has the opportunity to appeal up to either an intermediate appellate court in state court or a circuit court in federal court. And that's really kind of how a litigation travels through the life process. There's a lot more complexity than that, but that's really, at its bare bones, what a case looks like in civil litigation.
And Matt, with that sort of life cycle in mind, when do you think is sort of the most opportune time? And is there sort of a too early, too late kind of issue that you wrestle with when evaluating opportunities?
It's an interesting question. And I actually, from Statera's perspective, I think all times are equally opportune. We fund cases at every stage that Jeff just laid out, from pre-complaint to cases that are in the midst of discovery, to cases that are at the summary judgment phase, cases that are about to go to trial, to cases that have a judgment from trial and are in the midst of an appeal. So we do them all, and I frankly don't have a preference or wouldn't identify any stage as opportune. I will say that early stage cases are taking funding earlier in the process may result in more expensive capital. It may be more expensive at the end of the day for the counterparty, but that's as it should be, and that's, I think, rational for all considered, because for one thing, as Jeff just laid out, facts and information are developed over the life cycle of a case. So if you're at the very beginning of the case, necessarily know the least, and thus there's higher risk, and thus it makes sense that the pricing, the required pricing from a funder would be higher, and the pricing that a counterparty should be willing to pay should be higher given the amount of uncertainty, as opposed to, for example, a case that's about to go to trial where the record is really well developed and it's easier to size up what's likely to happen. And then also, capital, the cost of capital in litigation finance increases over time, just as a function of the time value of money and other factors. So if you take funding, at the complaint stage and a case goes on for 3 years, the funder's return, if there is one, it's probably going to be higher than if you take funding just before trial, for example, where maybe the entire life of the funding relationship is much shorter. So yeah, I wouldn't call one more opportune or another. I've heard, it is nice to have, for example, a motion to dismiss decided and to see the judge's initial take and to see the defendant's initial arguments and sort of framing of the case. It's certainly nice in terms of having confidence in our underwriting. And I've heard that some funders actually won't look at cases that aren't past at least the motion to dismiss phase. But I don't know whether that's true or not. I don't have perfect information. But as I say, it's Statera, we do cases even before a complaint is drafted. It's harder to do the diligence and the underwriting in that posture because you have to sort of issue spot on a blank slate. But I wouldn't call one more opportune than the other.
And just to emphasize something that Matt said, and I think a key issue to remember for litigation finance is that it is non-recourse, so that to the extent that the litigation produces no result or no income, the funder gets nothing. And so naturally, that means that to the extent you're funding a case early on, before facts have been developed, even before a complaint's been filed, I have to explain to clients that funders, they require a good return on their money because they're putting in a fair amount of risk, as opposed to we also see funding in post-judgment, so appeals stages where you have a pretty good level of confidence that you're going to get something. It's just not clear how much. So there is real risk, substantial risk involved for a funder here.
It's really a risk analysis in terms of what do you want. For example, let's say you're going with a traditional litigation funder, right? And you're coming in early, meaning they're going to be funding all of the litigation costs and bear, the risk. Now, there's obviously risk to the counterparty as well, but when you're putting the money up to pay for that risk, there's a trade-off there. But you're also, like I said before, getting the expertise of the litigation funding firm, and it's at what stage do you want or need that. So, the opportune time is when there's a so-called classical meeting of the minds in terms of what cash do you want to help support the litigation? What is the risk premium you're willing to pay for that? And how much risk or not is the funder willing to accept and take on the case? So those are all the variables that go in. But, much like Matt said, every case is unique. Every funder is unique. Every fundee is unique. And so it's got to be just like when you're buying or selling a house, a meeting of the minds on what the financial terms are and the timing and everything else.
At the risk of getting a little bit ahead of ourselves, listening to your comments as a group, I'll throw out a question. When you get litigation financing, does the litigation funder take on all of the costs, or do you find situations where there's a cost sharing? So the principal party says, I'll do 35% and I need financing for 65%. So every dollar is sort of shared, or is it really, 100% financed? Or is there like an equity commitment, if you will, required by the party?
I'll answer for Statera, and then Jeff's experience may be a little bit different. Every deal is different, and we pride ourselves on being creative and not rigid or locked into any structure. That said, there is a predominant structure at Statera, and I think in the industry generally, and that is where we will pay the majority of the legal fees, but not all of the legal fees. Call it, somewhere between 50 and 75% of the legal fees. And the law firm takes a discount on that delta, the 50 or 25%. And that discount is treated as an investment in the case, entitling them to a contingent return upon a successful result. So like a success fee or a success bonus or something of that nature. And the structuring can go a lot of different directions. And then typically we'll pay all of the hard costs. So the funding typically is used to pay hard costs such as experts, et cetera, and the majority of the legal fees with the law firm sort of contributing to the case by taking a discount, which we like, and I think every funder likes because it aligns incentives in useful ways. And then sometimes for us, but not always, sometimes the counterparty will also co-fund, if you will, and be responsible for continuing to contribute some amount that goes towards fees and or expenses as the litigation progresses. But that's not always the case. And so that's the predominant model. That's the most common model, but I definitely don't want to suggest that it's ubiquitous. I mean, sometimes we do what are called monetizations, where we just we give the counterparty money for them to use for operating capital, for working capital, for whatever needs their business has, and the money doesn't even go to the lawyers or the experts because they're accounted for in some other way. So there's an infinite number of structures, but I describe the predominant one from our perspective. Jeff, is that similar to your experience or not?
Yeah, Matt. So at GLS Capital, I mean, our experience is pretty similar to yours, both in terms of flexibility on deals and what the predominant structure looks like. David, to kind of answer your question a little bit more directly on counterparty contributing, I would say that happens. I can think of a couple deals off the top of my head where the litigant was effectively co-funding along with us because they had the capital and they wanted to participate. And sometimes it would even get to the point where they were effectively funding alongside us in similar funding vehicles. But that's usually not the most common mechanism for a couple of reasons. One is which, usually the people that are coming to us don't have either the funds or the liquidity in order to go forward with the litigation, which is why they've come to us. They've used up their capital. Oftentimes, it's more common for the litigant to actually use all their capital to get, let's say, the complaint drafted, motion to dismiss, solved, and early discovery. Then they come to a funder. So in some way, their contribution to the case is getting the case further along so that, the funder share is a little bit less because the case is more mature. The most common sort of contributor to the case is exactly what Matt laid out, is lawyers doing either full contingency or partial contingency on the case, whereby they are doing, part of they're lowering the amount or all of their fees in exchange for some portion of the recovery of the case, in essence, funding it through their law firm in that way. And that's a pretty common, although not necessary, structure for a funding relationship. And that's one that I would say is probably the majority of what you would see in single case fundings. That's really sort of the risk sharing that's most common for funders to see. And that's really how it typically breaks down, and it can get even more complicated in portfolio or law firm portfolio deals. But that's usually how it appears to us when it comes and how deals typically get done.
I want to dive more into the process, and I think if you're listening closely, you've heard Matt talk about monetization as a type of transaction. We've talked about portfolio funding and single case funding. For the next few segments, my questions are going to be focused mostly on single case funding. I think if you have questions about monetization or portfolio funding, it's a great opportunity to talk with Paul and Jeremy to the extent we don't get to it during the rest of the webinar. So with a single case sort of paradigm in mind, Jeremy, what's the first step? How do you start this process?
So really, it's exploring the right partnership. We talked about the types of funders earlier in this episode, but it's finding the right partner or partners, right? Sometimes they're not too complicated, but sometimes there's some sharing among firms, right? But it's going to either using a broker, or you talk to your attorney for connections in the field, and finding the right partner. It's one of those where, to use my house analogy again, you could look at 400 people could look at the same house and only 2 want to submit offers. It very much, depending on the situation, may be the case here, right? There are some specialized funders that like certain case portfolios and others that won't touch it. Maybe there's a size of a deal. Some funders won't want to touch it unless it has, 8 figures. Others are happy to do smaller deals. So it's finding the right fit. But what are you giving? It's a package. Every funder will ask for certain diligence materials about the case, the background, the plaintiff, the defendant, kind of analysis has been done, but it's packaging that up and then finding the right partner to start talking about it, right? Once you find that partner, then you move on to things like term sheet and actually the documentation. But the first step is putting together what it is that's the claim or the case, and finding the right partner and talking about what the terms are.
And Paul, is this, again, coming from my private equity background and sort of M&A world, I think of putting together banker books that talk about like the target, what it does, the investment highlights. Are these banked processes, or even if it's not a banked process, are there offering memoranda? I mean, how do you go to market, and do you focus on specialists? What's the go-to-market strategy?
Sure. I think the first thing I explain to clients is that it is a process. So it is not simply like walking into a bank and getting money. The first thing we tell them is before you even approach funders, it is important you have your package together. Jeremy mentioned it. I think the keys are to have a good memo explaining the case and including the merits of the case and an honest evaluation of the weaknesses of the case. 2 is a budget. You really need to work with your counsel to come up with how much money you think it's going to really be to try to take the case, and stage by stage. And then finally a timeline. Like what is the line like? What is the timeline like? And with that process, you can start going to funders. The other thing I caution clients about is funders are very picky. So they take, I'm sure these guys can tell you, they take less than 10% of the cases that they see, maybe less than 5% of the cases they see. So I have to explain to them there's a process. I think with a good counsel like Jeremy, they can guide you to what funders might be appropriate for certain types of cases. But even once you find a funder, then there's a lengthy diligence process, which I think, as has been mentioned, can be very valuable because funders are very tough and they pick through the minutiae of the cases and they're quite expert. And I find it for my clients, it can be quite an education to get an objective viewpoint on the case. And ultimately, even if the funder declines, you really are getting value by going through that process.
Matt, from your perspective, are you sitting by the phone waiting for it to ring from Paul and Jeremy, or what's your sort of outbound outreach, if you will, for generating leads?
Well, as a background matter, yes, I am always sitting by the phone waiting for Paul and Jeremy to call me, but I'm also doing other things. We get presented with opportunities from several sort of channels. The key ones being probably the most prevalent being the law firms themselves, although they are not the counterparty. They are the repeat players in this space. And if they have a would-be client or an actual client with a meritorious claim who is interested in getting funding, they are they're often the ones who know who to call. So we get a lot of our looks, as it were, from law firms, from litigators or transactional folks at law firms. There's a broker, there are brokers in this space. You cited Westfleet earlier. They're a leading broker and sort of information clearinghouse in our space. So a client might hire a broker, and the broker can sort of assist them through the process and make sure they're talking with the right people and going about it the best way. We occasionally get inquiries from sort of investment banks who are helping traditional clients in this particular, corner of the financial world. And not insignificant number of opportunities come to us from the commercial counterparty themselves, the claimant or the client can contact us directly and often does. So those are sort of the channels, and there's a relatively even split amongst them. I don't think I left anyone out.
Jeff, Paul had mentioned that litigation funders are very picky. I think I read somewhere that one of your competitors, Burford, for example, looks at 12,000 matters and funds some very small percentage of them. From your perspective, can you just give some color on deals reviewed, deals accepted? And I think, again, from my private equity experience, we underwrote deals for sort of a 30% IRR, 3x cash on cash return. What's that initial underwriting look like from your perspective?
Yeah. So, I mean, in terms of cases we look at, I mean, it's hundreds and hundreds and hundreds a year that flow through GLS Capital and the various colleagues and myself that kind of take a first pass on them, and this builds up to thousands over the course of years. And in terms of, as the cases move on to the next step, a lot of them get screened out pretty early on. When you have a forum submission on your website, you can imagine the types of cases that may come in through that. Some are quite good, many of which are not. And so a lot of it is sort of that first screen till you get to a colorable case with a law firm of quality and a size that makes sense. But even once you sort of dig into the merits, I would say that 5%, less than 5% number is probably pretty accurate in terms of cases we see to cases that we close deals on, because it has to be large enough. It has to have the merits strong enough. The party needs to be able to want to do a deal for funding at the economics that makes sense and the risk profile that makes sense for us. And then there's also a few kind of nuances to it where sometimes cases may be really strong, but you're not going to know whether they're strong or not until you're in the middle of discovery. Maybe you need to look at the source code for the defendant to know whether it's a great case or a terrible case. And those are often cases that are not good for funding because the unknowns take a long time to develop and a lot of money might need to be spent. So the cost of capital will be particularly high. And so that's, kind of a little bit of a glimpse into the pipeline in terms of how pricing works in our industry. I mean, in terms of relatively straightforward commercial cases, everyone does it a little bit differently. I mean, I think that if you kind of hear people in our industry talk a lot about business disputes, once cases get to trial, usually funders are looking for 3.5x on their deployment. So if we deploy out $1 million, that's 3 million or 3.5 million back. And that can be incredibly imprecise description because some cases are way less risky. Many cases are way more risky. So it's hard to kind of pin any kind of pricing onto that. But kind of the back of the envelope math of the industry is that you take the pricing we put on a deal, you realize that no matter how good I think I am at underwriting or how good Matt is, we still lose a not insignificant number of deals that we go out with because judges can be random. Juries can make decisions, based on things that are not the merits. And facts can develop in discovery that would have been unforeseeable when you're initially making that investment. And because a lot of our deals go to zero, obviously the economics have to be high enough that it can be a risk adjusted, let's say 2x is often a number that gets thrown around in our industry. And that's kind of how the math works. Every funder is a little bit different on that, but for single case investments, those numbers are not that far off from the market norm. And it can sort of adjust along the way because everyone thinks their case is the best, but there's a lot of risk in litigation out there.
And I'll preface this next question by allowing you to dodge it if you'd like. And are there courts that you just stay away from? I mean, I think in the federal court system, which I have some familiarity with, you think about the Fifth Circuit being particularly conservative, and maybe the Ninth Circuit is particularly liberal, and so different circuits might have different reputations. Are there courts you try to that you're dissuaded from funding, if cases funding in those courts?
So I think the short answer is no. The longer answer is that the court system typically isn't as sort of systematically biased in one way or another when it comes to boring business versus business disputes, which is the core of what litigation funding looks at. Oftentimes, the problems are often more about a court being unusually slow or a judge being kind of unusually intemperate compared to something else. And so you can have those considerations take into effect, but I'm not sure that there's, courts within the United States at least, that, are a red X on them. There are courts that I like less and the cost of capital may be higher, or I may be a little bit more sensitive to what judge you get within that court system. But I think that, we're not looking at complex constitutional law usually. It's a breach of contract between two businesses localized in that state or national businesses. And so there really isn't the same valence of, political bias that may be in other cases. And again, if you're talking about courts outside of the US, there are places, but within the US, I feel like there isn't any sort of courts that are off limits per se. Maybe Matt disagrees with me.
No, I've agreed with basically every word you've said for the last several minutes, Jeff.
I love that.
And yeah, I would emphasize the same point. It's more relevant in my experience, the duration than likelihood of success. And that, I mean, one thing that's been interesting to see is as we look at thousands of cases and invest in dozens and dozens is to get a more sort of fluent understanding of the different jurisdictions. And one thing that's striking is how certain courts, certain states have procedural vehicles that either have the effect of or are actually intended to slow plaintiffs down and disadvantage plaintiffs. For example, I can think of two states that have implemented interlocutory appeals of right on behalf of defendants at junctures in the case where other jurisdictions, including the federal jurisdiction, would not stop the case. So in those jurisdictions, the plaintiff gets to that point, prevails, gets over that hurdle, and then has to go up and defend an appeal for a year, 18 months, 2 years before they can continue with their case. Similarly, you see this in IPRs with patent litigation. These are procedural components that materially affect the duration of a case and thus affect the prospects and terms of funding. And in a couple of these jurisdictions, they do it intentionally. It's a sort of function of tort reform over the last decades that the lobbyists on the sort of the defense side have implemented these abilities to to interlocutory appeal. Now, when I think of interlocutory appeals, I immediately think of New York, and I actually wouldn't put New York in the bucket of a state where interlocutory appeals are overly concerning or problematic. I've always thought it's odd the extent to which you can do interlocutory appeals in New York, both as a practitioner and a funder. But the first department and the second department are so fast, and they write such short opinions. And New York is such a sophisticated jurisdiction that it's not. That's not one of the ones I have in mind when I flag the possibility of interlocutory appeals as affecting the underwriting.
There are a number of slides that I'm going to skip over, but want to just direct your attention to them. So this is slides 24 to 31, 32. These talk about some ethical issues that you need to consider. There are some historical policies, terms you may have heard of called champerty and maintenance, barratry. I think those have largely gone by the wayside. We covered them a little bit in episode 1. Draw your attention to the attorney-client privilege issues on slide 31. Jeremy and Paul have both mentioned the need to have confidentiality agreements with the funding sources to protect the privilege. I want to turn to now, that's here you see confidential on slide 33. I want to turn now, Jeremy, to talk a little bit about structures. So we've heard the terms non-recourse and want to understand if this is it a loan? Is it a revolver? Is it a delayed draw term loan? Sort of, those are terms that are familiar to me, again, from my world. Maybe you could talk a little bit about what is the form of this transaction?
Sure. So really there's two forms. It's kind of like a loan agreement. It's kind of like an M&A document. If you took those and kind of smushed them together and pulled out some terms, and that's kind of what the agreement looks like. But there's really two forms that this can come in depending on, and there's tax considerations for each. But one is the financing agreement, although it's not a financing agreement like you would necessarily see at a bank because of the non-recourse nature, like we've talked about already in this episode. The more common, at least from what I've seen, is a prepaid forward model. And what that means is you are essentially buying a property interest. Litigation funder is paying money towards a case, and in exchange, it gets a property right in the recovery. So it takes the form of a prepaid forward contract. But like what I was saying before, it's sort of like a loan agreement smushed with an M&A agreement, because you obviously have the business terms, what's being funded, what's the commitment amount, what are the criteria for funding, things like, reps and warranties. The indemnities are going to be specific. It's not going to be like your overall indemnity. There's but for, breaches of basic reps, hey, these are the two owners. We have the right to bring the case. There's no encumbrances that affect this. So there's a breach there. That's where one of those limited exceptions where there may be some recourse recovery. But the other components of the document are, along the lines of what we were talking about with a waterfall, meaning if proceeds come in, who gets what, when, where, right? It may be that the funder gets back all their money in the return, like we've been talking about, and then everybody else. But that's something that gets negotiated. So from a general perspective, again, the structure is either a financing agreement or a prepaid forward contract. And the substance of it contains lots of things that would be similar to David from your practice, that you would expect in a loan type of agreement, or an M&A deal, but not exactly. It's its own animal. But those are the two structures.
And while he's not here to defend himself, one of the panelists from our first episode is from Burford, and we talked a little bit about some cases where Burford was exercising remedies and trying to step into the shoes of the litigant. So, Paul, maybe you can explain a little bit about these situations. When would a remedy arise, and what would trigger it, and how does that work between the parties?
Of course. So, the first thing I'll say is that no matter how good your lawyers are, it is important that there be a good relationship amongst the parties, because lawyers cannot account for everything that's going to happen in a litigation, which could take 3 or 4 years. So, one is a relationship, which I think our funder colleagues mentioned. Two is ensuring that your parties are economically motivated to be in alignment, which is why we spoke about both the plaintiff, the counsel, and the funder all having economic incentives to come to a resolution that's beneficial for all three of them. But as Jeremy mentioned, the form of the documents, they look a lot more like a loan than they do like anything else, even though in substance they're really not loans. And so typically in terms of collection risk that the funder needs, they need to be careful about. There is often collateral or security put up. At a minimum, the funder will take a security interest in those future proceeds. So the funder will typically file a UCC financing statement. We often also see personal guarantees, what we call bad boy guarantees. These are going to be in cases in which the fundee is either a small enterprise with several partners, or a small law firm that's getting funding. And bad boy guarantees are designed specifically. They don't give recourse, but they are designed to prevent basically fraud and theft. So it's really on the far ends of misconduct. But otherwise, you have the same covenants in a prepaid forward purchase agreement that you might find in a loan agreement. Covenants regarding compliance with the terms, your conduct as far as the litigation goes, to continue to pursue the litigation, to keep the funder informed about what is going on. And often control is a no-no. So funders having control is really a concern. And the discussion of you mentioned that Burford case in which one of the courts took that quite badly. But consulting rights, it is important that a funder wants to know what's going on. And there is often a sort of fatigue provision in which, to the extent that the funding is not all upfront, but is drawn down over time to pay expenses, to the extent that at some point the litigation just is clearly a loser, and the funders often have the ability to cut off funding at that point to prevent wasting of fees.
In that situation, if you sort of look at that with the duty to litigate, and if the client is capital constrained, are they forced to dismiss voluntarily, accept a judgment by the other side? What happens in that situation if a fatigue provision is triggered?
So I often have concerns of that, because clearly all funders want to avoid being seen as having control of the litigation. But there is an argument to be made that to the extent that they're controlling the money here in that way, to the extent that they cut it off prematurely, or because they just disagree with the strategic decisions that the plaintiff is making, that could be presumed to be control. In my experience, though, funders don't do that. So my experience, funders generally will only cut off funding to the extent it's clear that the case is going nowhere and it's simply a churning of legal fees. And maybe Jeff and Matt can maybe they have experience with this provision.
Very little, thankfully. And yeah, the term fatigue clause is an interesting, colorful one. I mean, I think of it more as like a MAC clause, and the sort of quintessential material adverse event is you got killed on summary judgment, and we're not going to pay for obviously futile attempt to come back from the dead. you know, it should, the way I think of it is pretty clear cut stuff where it would be irrational for anybody involved to continue throwing good money after bad and good time after bad. The notion of cutting off funding because of a strategic disagreement is anathema to me, and certainly not something that we've ever done. We are absolutely rigorous and earnest when we say we have no say over strategy or settlement decisions or the like. So I think of it more as sort of a math clause. If something goes really wrong and you're clearly sunk, we're not gonna keep throwing money into the ocean.
This is one of those clauses that I think are interesting because it comes up often in negotiations where you have the counterparty, the fundee say, well, what happens if you just stop giving us money? Right. And you can spend all sorts of time negotiating, agreement to subordinate if they get additional funding. There's this huge concern. And there's some reputational issue here, right? That if a funder just stops midstream for no good reason, assuming they have that right to do that, that the fundee is going to be out on the diving board all by themselves, floundering. The truth is, funders aren't going to start giving you a dime unless they believe in your case, right? And it's only if as Matt said, you have a true MAC that nobody in their right mind would look at it and go, oh, you know what, this funder wants out. Oh, get me in there. I want a part of this case, right? It's just not practical. The other component of it is, to use a poker term, right? At some point you get pot committed. So if you funded a certain amount, and even if the case isn't like going ideal as everybody would draw it up, at some point it's worth spending a little bit more money to try and reach conclusion. And even if it's not looking fantastic, maybe it's only looking good, it still makes sense for somebody to fund. Somebody's not going to step out. The last thing I'll say on this is, again, a lot of fundees get, well, what happens if, right? And the truth is, if you get to that point, I have found most funders are going to be rational, right? So if funder one thinks this is a loser and won't fund it anymore, but funder two is willing to come in and see it through to fruition, where that could result in funder one still getting a recovery, funder one is going to say, okay, great, because otherwise I will have lost everything I've already put in. I'll agree to be reasonable at the time, depending on what the circumstances are. So does that mean I'm going to take a lesser return? Maybe. Does that mean I'm going to agree to be subordinated in that circumstance? Maybe, right? But people try and negotiate this sometimes up front, and you just have no visibility into what the situation is going to be. And from my opinion, not to be overly biased here, but people spend too much time and energy trying to negotiate something around this that nobody can see what it is. And again, parties are going to act rationally at the time. Sorry.
So we have a couple minutes left. I want to do a quick lightning round, and the topic for the round is practice pointer, trap for the unwary. Pick something that you think our participants and attendees should take away as your best bullet point highlight. And so I'll just go based on how you appear in my screen. Jeremy first.
Go with parties that know. If you're interested in litigation financing, use people that know the space, whether it be attorneys, funding partners, brokers. It'll go much smoother using people that are experienced in the field.
Jeff?
When you're presenting your case and talking to a funder, focus on damages. Usually people have a good sense of the merits of their case for liability, but people don't think through the damages. They view that as something they'll deal with later. And many times we wind up not funding more on damages than we do on liability.
That's an interesting distinction. Because I have seen situations where liability is clear and damages are much less so. That's a very important point.
Yep.
Paul?
Yeah, so again, I'll focus on relationships. I think when you either for a funder or for a plaintiff, when you're talking with each other, act like you're not going to do one deal together, but you're going to have a relationship and do multiple deals and try to treat each other that way. And usually you get the best deal that way.
And Matt,
Jeff stole mine, but I'll augment it a little bit, which is there's a counterintuitive dynamic where I think that a lot of lawyers and counterparties think that if they come in and tell us the damages are huge, that we're more likely to do the case. And my experience is it's actually the opposite, that that measured and sober damages are much preferable to somebody coming in and telling me that they're going to make billions of dollars on a case. And then the other thing I would layer on is collectability, which, you know, I was at Williams and Connolly, and Jeff was at Kirkland, didn't spend a ton of time thinking about or talking about collectability. But in the realm of litigation finance, you can't, it's not enough just to get the judgment and survive the appeal. You actually have to get the money too, somehow. And just as with damages, where sometimes lawyers don't necessarily pay as much attention to that at the front end as we would like, you need to have a clear line of sight to the actual collection of the damages at the end of the day.
great point. We are out of time, and you can tell we only scratched the surface of what is a broad, complex transaction business environment, and really requires the advice of professionals like Paul and Jeremy and sophisticated investors like Jeff and Matt. So I encourage you, if you have a situation, to reach out to any of them and talk it through with them. I appreciate your participation, and thanks for listening.